In this section, we will talk about how New York Attorney General Letitia James led a coalition of 24 attorneys general in filing an amicus brief to the Supreme Court in support of the CFPB's constitutionality and its authority to investigate and enforce consumer protection laws. The CFPB, or the Consumer Financial Protection Bureau, is an independent federal agency that was created after the 2008 financial crisis to protect consumers from unfair, deceptive, or abusive practices by financial institutions and other companies. The CFPB has the power to issue rules, conduct examinations, bring enforcement actions, and educate consumers about their rights and responsibilities. However, the CFPB's independence and authority have been challenged by some who argue that it violates the separation of powers and that its director can only be removed by the president for cause. In 2020, the Supreme Court agreed to hear a case called Sila Law v. CFPB, which involved a law firm that refused to comply with a CFPB investigation and claimed that the agency was unconstitutional. In response, Attorney General James and her fellow attorneys general filed an amicus brief in March 2020, urging the Supreme Court to uphold the CFPB's structure and authority. They argued that the CFPB is vital for protecting consumers from predatory and abusive practices, especially in states that have limited resources or weaker laws. They also argued that the CFPB's independence from political interference is essential for ensuring its effectiveness and accountability. They cited examples of how the CFPB has helped millions of consumers recover billions of dollars in relief and restitution from various financial institutions and companies. The attorneys general also pointed out that Congress intentionally designed the CFPB to have a single director who can only be removed for cause, in order to insulate the agency from undue influence and ensure its stability and continuity. They contended that this structure does not violate the separation of powers, but rather reflects a reasonable balance between executive oversight and agency autonomy. They noted that other federal agencies, such as the Federal Trade Commission and the Social Security Administration, have similar removal protections for their heads. The amicus brief was co-led by Attorney General James and California Attorney General Xavier Becerra, and joined by the Attorneys General of Colorado, Connecticut, Delaware, Hawaii, Illinois, Maine, Maryland, Massachusetts, Michigan, Minnesota, Nevada, New Jersey, New Mexico, North Carolina, Oregon, Pennsylvania, Rhode Island, Vermont, Virginia, Washington, Wisconsin, and the District of Columbia. The Supreme Court heard oral arguments in the case on March 3, 2020. On June 29, 2020, the Supreme Court issued its decision. The majority of the justices ruled that the CFPB's director can be removed by the president at will, but that the rest of the agency can continue to operate as usual. The dissenting justices argued that the CFPB structure is constitutional, and that striking down the removal protection would undermine its independence and effectiveness. Attorney General James issued a statement after the decision, expressing her disappointment with the ruling but also her commitment to continue working with the CFPB to protect consumers.